Well, thanks everyone for being here. I really welcome the opportunity to speak to an audience of judges and others who are concerned about addressing these issues. I normally am a bit more partisan in my discussions and in my work, and I'm going to try to, as objectively as possible, lay out the rules that I understand them. And I'm going to do it in two parts. First, I want to talk about what I primarily do, which is litigation under the Alien Tort Statute, a federal statute, and then talk about a couple of state law cases I have that raise international law issues in state courts, and circle back and talk about the common issues. I want to put all of this in context first, though. I think that this entire discussion has an unstated premise, which is, why are these cases, any case that has international issues, international plaintiffs or defendants, being brought in U.S. courts? And from my perspective, as a person who initially was working with human rights groups and labor groups here in the U.S. and eventually became a full-time litigator because someone needed to do it, we did try and always try to figure out how we can bring these claims in the courts where the events occurred. But for the most part, when you have situations of egregious human rights violations occurring or unanswered systematic violations of law, there's a reason why the people don't bring the claims there. In the legislative history, for example, of the Torture Victims Protection Act, which was passed in 1996 as a confirmation of the Alien Tort Statute in a limited fashion, there's quite a bit of information in there about why the U.S. courts should be open to these cases. But at the end of the day, the answer is that it's very unlikely that victims of widespread torture or other human rights abuses have a forum where they're able to bring their claims safely without fear of violent retaliation and with some chance of getting justice done, so that the U.S. courts are, in fact, open. Now, I also want to put in context that there were other tools that we all tried to use before we resorted to litigation, and those include research and exposure of events occurring, particularly when U.S. multinationals were involved. We experimented with the viability of codes of conduct, and I view that as an unsuccessful experiment, that absent any kind of viable threat of litigation, that the codes remain voluntary and subject to the discretion of the issuing company on whether they're going to comply. We've experimented with trade sanctions in various U.S. laws, and that process is very politicized and is not particularly reliable as a result of that. We've used the International Labor Organization and the petitioning process there with the Committee of Experts, and while we received some incredibly damning reports, there's just no enforcement mechanism that is available. And we've tried consumer campaigns as well. There's a couple of campaigns I'm associated with. One is called the Killer Coke campaign, and one is called Stop Firestone, both dealing with offshore activities of Coca-Cola and Firestone. But those are long-term projects that really don't provide remedies for people who have been harmed by human rights violators. So at the end of the day, in terms of our goal with the human rights and labor groups I worked with was to try to find a way where we had some sort of legal stick, some kind of case that could be brought that would serve a couple of functions. One would be getting relief for the particular people who claimed they were injured, but also, and I hope and understand Jonathan will talk about this a bit, that if there is a viable stick out there, then that gives companies some incentive to try to do preventive work, to try to come up with compliance mechanisms and human rights checklists so that they don't find themselves in court. And that is something we are absolutely in favor of and try very hard to cooperate with those efforts. And so with that said, I want to now just cover what are the major issues of this litigation using the Alien Tort Statute, and then again pick up with some state court issues that might be of interest as well. For those of you who don't know, the Alien Tort Statute is a statute dating back to 1789. It was passed by the First Continental Congress, and it has exactly 16 words. It's something to the effect of the federal courts shall have jurisdiction for suits brought by aliens for violations of torts that are within the law of nations. And that's it. There were a couple of cases after the statute was passed involving either rights of ambassadors and their rights of passage, and there were a couple of piracy cases. And then essentially the statute was dormant for quite a while until about 1978 when a New York group, the Center for Constitutional Rights, found this statute and used it in an effort to hold accountable for human rights violations that were committed in Paraguay, a Paraguayan colonel who had murdered and tortured people in his capacity as a colonel in the national police in Paraguay, but then he moved to the US and got asylum and was living in Brooklyn, New York. At a market in Brooklyn, some relatives of people that he had killed or tortured saw him there and then began a process of trying to figure out, well, how can we bring an action against this guy who's now subject to personal jurisdiction in the US, who has committed human rights violations in Paraguay. So they found this alien tort statute, it brought the case, and it went up to the Second Circuit, which, in a very clean, simple decision, essentially looked at the 16 words of the alien tort statute, looked and found 3 elements, and found that there was a cause of action. They found that the elements were that you had to be an alien, you had to be a victim of a tort that was also within the law of nations, which they interpreted, and subsequent courts have generally agreed, is a look at what the international community generally enforces as its laws, and trying to find those norms that are sufficiently universal, specific, and obligatory to be able to say that you could actually apply that legal standard in this case. So with the Filartiga decision, the new modern era of the human rights litigation under the alien tort statute was born. I got involved in 1996 and brought the first case that was targeting a US multinational. It was a case against Unocal Corporation. They were building a pipeline in Burma, Myanmar, and they had a joint venture with the government of Burma, which is a military regime. And as part of that, the government's responsibilities, they were supposed to provide security and do some infrastructure work for Unocal and their French partner Total. As part of that process, they went into villages, rounded up people at gunpoint, my clients, and made them clear the jungle, act as human minesweepers, and do other things in furtherance of the pipeline project. So we sued Unocal using those 3 elements that our clients were aliens, they were victims of tort, which involved physical abuse and forced labor. And our argument for the law of nations violations was that this was, slavery clearly was a law of nations violations. We argued that forced labor is a modern form of slavery and that it is universally condemned, it is sufficiently specific, particularly because of conventions of the International Labor Organization, and that it was specific enough to enforce as a norm. So we brought the case, we went up to the Ninth Circuit twice, if you count the en banc, and then on the eve of a jury trial, we settled the case. That case provided a lot of the legal issues, resolution of a lot of the legal issues, or at least identified most of them that have subsequently been addressed in the new area of corporate cases under the Alien Tort Statute. In 2005, the Supreme Court took its first modern look at this Alien Tort Statute in a case called Sosa versus Alvarez-Machine. And in that case, in a 6-3 decision, the court essentially agreed with everything Filartiga had laid out, that there is a cause of action. That was the big debate, whether it was merely a jurisdictional statute that required some other enabling legislation, or did it itself create a cause of action? And the Supreme Court held that it does, that you have to identify norms with a sufficient level of specificity, such as existed for norms in 1789, and then use the same test that Filartica had identified, that it has to be specific, obligatory, and universal. So with that, certainly Sosa raised a number of other questions, and some of those remain unresolved. I would like to just briefly run through what I think are the main legal issues that we have today in bringing these kinds of cases. The first, of course, is which norms are within the law of nations definition. And I think that today I could announce a list that is really fairly short and concise, and it'll probably stay that way for quite a while. It includes certainly torture, extrajudicial killing, genocide, war crimes, slavery/forced labor, child labor. We recently got a decision in a case against Firestone for their activities on a plantation in Liberia harvesting rubber, that child labor itself is a norm under the law of nations. And then I think those are all fairly certain. There are a few that are less certain, but there are cases going both ways. One is prolonged arbitrary detention. Sosa itself rejected the issue in Sosa was a detention, but it was a matter of a couple of days, and there was some judicial process involved with the Mexican authorities, allegedly. So the court there said that was not sufficient, but in its citations to other authorities seemed to approve of or implicitly agree that some form of prolonged arbitrary detention out there would still be actionable. And there are cases that have subsequently found that to be the case. Crimes against humanity, it seems to most of us who do this work that if war crimes and genocide are actionable, crimes against humanity is of the same caliber of definition and universal condemnation. There's no appellate court that I'm aware of that has ruled on that, but several district courts have said yes it is, and several have said no it's not. The same with cruel, inhumane, degrading treatment or punishment. There are plenty of district court decisions that say that that is, it's sort of in the people who work in this area call it torture light, that torture is something that we all can understand what it is. Cruel, inhumane, degrading treatment or punishment is something less than that, but it is well defined in terms of the need for some kind of physical attack or mental attack on an individual. And I believe the Ninth Circuit has this issue before them in a case called Bowoto versus Chevron that is pending. There was a recent case that is now before the Supreme Court on a yet not granted cert petition called Abdullah versus Pfizer, where the claim there was that Pfizer authorized or participated in medical experiments on children in Nigeria without their knowledge, and that is itself a violation of international law, that sort of non-consensual medical experimentation. There are some cases going back to the Nuremberg tribunals that made some law on this. So the Second Circuit affirmed an award and found that it was a norm, and Pfizer's asking the Supreme Court to review that. Now, I do have to pause after going through that list and simply say that that's probably the list. There are some other possibilities out there, but for the reasonably near future, with the really strong language in Sosa from the Supreme Court that there should be vigilant gatekeeping and that this is a narrow list of norms, it's unlikely we're going to expand that much. So from where I sit, when I see people who are just strongly opposed to the idea of this litigation and want to argue why it should be completely shut down, whether in Congress or in the Supreme Court or in any other number of ways, we have to circle back and say, well, let's think about this. I mean, if the issue is being liable under that list, from genocide to torture to extrajudicial killing to slavery, there shouldn't be a whole lot of interest or policy behind it that is wanting to protect the right to do that, to wanting to shield people from liability for those kinds of serious crimes. And I always urge the corporate community when we're having these kinds of debates that we should figure out a way to spend our energy on compliance so that there are no American-based companies or individuals that could possibly be found to be liable for that list of serious crimes. Now, just going on briefly in my remaining time, I'd like to talk about a couple of the other key issues and then talk about state law issues. The other really contentious issue that has a lot of room for development by the courts is what the standard of liability is. Once you've identified the norm, that's sort of the gateway into the Alien Tort Statute, particularly in these corporate cases where often the particular company did not itself torture or kill people. It either was working with a military regime, a battalion that it privatized to be a security force, or paramilitary groups in places like Colombia. So the issue is, what did the company have to do to itself be liable for the principal actor's actions? And there are 4 theories of liability that we and others have used. The first is aiding and abetting, there's conspiracy, there's agency, and some kind of joint venture, particularly if there's a contract between an oil company, let's say, and the government, as we had in the Unocal situation. Aiding and abetting, by most opinions, is the easiest one to establish, and so it's gotten the most attention. And so there are 2 levels of debate here. The first is, what source of law determines the standard for aiding and abetting? Because there's one school of thought which is, once you've satisfied the gateway of the ATS and you have a law of nations violation articulated, then all of the other subsidiary issues should be determined by federal common law. And that would allow us to look at the restatement of torts and what other states have done, what the feds have done in terms of any common law developments. The other school of thought is that these kinds of issues also must be determined under the same standard as the gateway tort, that you have to look to international law and find that there is a specific universal and obligatory norm that articulates the standard of liability. The courts are roughly evenly divided without a whole lot of careful analysis, but recently the Second Circuit has gotten all excited about this issue, and in a decision called Presbyterian Church of Sudan versus Talisman, the Second Circuit issued a startlingly different opinion from some of its prior statements on this, and has held that aiding and abetting requires a look at international norms, and that the Rome Statute is going to be one of the primary sources of that, and that it requires more than just knowledge. It requires some kind of shared purpose with the direct perpetrator. Now, that's a long discussion in and of itself. I just wanted to flag the issue. There is reason to be concerned that this standard essentially obliterates the difference between conspiracy and aiding and abetting, where conspiracy does require a shared purpose and aiding and abetting typically did not. It required just knowledge that the primary actor was going to go out and commit this act. On the other theories, there's not as much law developed, again, because mostly they have focused on aiding and abetting. There are plenty of courts, including the 11th Circuit, that have said that it is simply the knowing and substantial assistance standard, which is consistent with what the restatement says. Other issues that are currently major problems in these cases are whether the plaintiffs have to exhaust local remedies before bringing a case here in the U.S. The range of opinions here varies from the 11th Circuit saying there's no exhaustion requirement at all, to a recent decision in the 9th Circuit, the Rio Tinto case, saying that it's a prudential consideration and it has, on a case-by-case basis, the court has to look to see whether there should be an exhaustion requirement imposed. Our own experience in bringing these cases is that we tend to bring cases from countries like Colombia or Indonesia a few years ago, China, where exhaustion could get you killed, and that certainly there's law that says if it's futile, you don't have to exhaust. So that tends to be in our cases where the action is demonstrating that it would be futile to exhaust. We also have, and this is something Dave Stewart and I met on long ago, the issue of whether there is a foreign relations type defense here, that can the U.S. State Department or some other arm of the U.S. government come into one of these cases and take the position that it should be dismissed because it might interfere with the U.S. government's foreign relations with another government. I've in fact had 2 of my cases dismissed, one against Exxon in Indonesia and one against Occidental Petroleum in Colombia, based on this defense that there is some foreign relations concern that was articulated. Those issues are both on appeal, and I think that they present a very fundamental separation of powers question of whether the executive branch gets to come in and essentially on a case-by-case basis veto a federal statute that creates a cause of action. There are other defenses that have been raised, including the political question doctrine, which I really still don't get how it would apply here because there is a federal statute that creates a cause of action. And the act of state doctrine, where the foreign state itself comes in to assert that the actions are somehow shielded because they're a part of official state policy. An overarching issue which is equally important in the state cases is forum nonconvenience, and whether a defendant can demonstrate that a case should be transferred to the location where the events occurred. We argue, although we've not yet really had a court accept the argument directly, that because the Congress has given a federal forum to these cases, that should negate the ability to even argue forum nonconvenience, because the federal forum was expressly opened by the Alien Tort Statute. But in most cases, this is not a problem for us, because in Colombia or some of the other places where these kinds of human rights issues are still fairly common, we're able to demonstrate there's not an adequate alternative forum. The one interesting case sort of teaching the lesson on the other side is that in about 1995, some villagers from Ecuador sued Texaco, which eventually became Chevron, in New York for human rights violations that occurred during the course of a major oil exploration project in Ecuador. For years there was a fight about forum nonconvenience. It went up to the Second Circuit twice, and then the case was ordered down to Ecuador. And in the meantime, the government not only changed, but drastically changed, such that the current president, Correa, is very much an advocate of holding Chevron responsible for billions of dollars of damages in cleanup and torts, so that now Chevron, after years of getting that case down there, is asserting that they're not getting a fair forum down there. So you often have to be careful of what you wish for, because these governments can change in places where these kinds of cases occur. The last major issue that we deal with is state action that, except for universal norms, and I think the courts generally say that's limited to war crimes and genocide, the plaintiffs in a case have to show that there was some form of state action. The general rationale for that is that human rights norms only apply to states and not to individuals, so that you have to introduce an element of that to your case. In cases where we allege that a government military force or some other government entity was a partner with a U.S. company, then we've satisfied state action. The challenge is illustrated by some of the cases in Colombia where we're identifying a paramilitary force, particularly the AUC paramilitaries, that did the bad acts, and we have to first establish that they were acting under a color of authority and then link them to the company. We have some pretty good evidence of that coming out lately, but I just flagged that as an element. One other thing to note for purposes of the federal cases is that when there was some doubt about what the Supreme Court would do in the Sosa case, well before that, there were earlier cases from particularly the D.C. Circuit, and there was an opinion by Judge Bork at the time, putting doubt on whether there was a cause of action at all. The Congress passed in 1996 the Torture Victims Protection Act, which is a very detailed statute that clearly creates a cause of action, but it is only limited to extrajudicial killing and to torture claims, so it's much more limited. Now, with just a minute, I think I've gone over time, I'd like to talk about possibilities in state courts. We have cases in state courts in California, in the District of Columbia, and we're about to bring another one in Missouri, that are just based on state tort law. And I think that a lot of those the folks doing this work are beginning to question why more cases aren't brought in state court, because you don't have all the hurdles, particularly the law of nations hurdle and the state action hurdle that you have with this federal litigation. And so as an example, I'll talk briefly about a case we have against Dole. We filed it in state court in California. It's a case, there are many cases like this in Colombia where American companies partnered with the paramilitary groups who were fighting a civil war. They were fighting against the leftist guerrillas called the FARC. And the companies eventually picked a side in that war. They sided with the AUC, the right-wing paramilitaries, gave them arms, support, bases, whatever they needed to get the leftists out of their property. So Dole and Chiquita, among others, sided with the AUC and gave them lots of resources. And in the process of doing that, these AUC units killed lots of people. In the case of Dole, we probably have about 1,500 families who had a family member who was killed by these paramilitaries. So we looked at the law, and as long as you don't have a forum nonconvenience issue, or you don't have one you think you'll lose, then there's no reason why you can't bring one of these cases in state court, provided that you can show some connection to the forum. So that in the case of Dole, their headquarters is there. We believe all the decisions were made there to make pay the paramilitaries and so on. And there's general jurisdiction. So we filed the case, and we expect that there are many other cases like this that could be brought. I think the biggest gateway issue there is forum nonconvenience. Now, I clearly have run out of time since I've got the note already, so I'm going to just stop there and hope that you have some questions that I can clarify any of the general points that I've made. Thank you.